Most of these player claims, nearly all of them are financed by third-party litigation funders. So they have already invested a lot of money into these proceedings. Court costs are very high in Austria, and they're not getting anything out. Yes. So maybe that's all can also put a halt to it, and they see first whether they can enforce at some point in time, and then they will start way more enforcement proceedings in Malta. And what we also noticed is a lot of them are probably waiting for the decision of the Court of Justice in relation to managing directors, because this is what really puts pressure on online gambling providers.
Hello and welcome to this new episode of WH Talks. Today I am with an esteemed guest from Austria, Nicole Daniel from DLA Pfeiffer. And I'm Davinia Kotayar, one of the partners at WH Partners. I had the litigation practice, and this episode today is going to be part of our series on disputes. We were thinking, Nicole and I, that we should cover what's been happening in Malta with all these enforcement cases that have been flowing to Malta from Austria. Over the past 2 years, we've seen hundreds of attempts to enforce judgments from Austria. These judgments were predominantly claims of players who were playing on Maltese licensed betting sites, and they were suing in Austria asking for a refund of gambling losses. In Austria, they were winning these cases, and then they were trying to execute them in Malta. And that's where we saw this influx of attempts to enforce. The Maltese operators maintain that they were operating in Austria legally. The Malta Gaming Authority supports that as well. We've seen this from evidence that the Malta Gaming Authority has given a court with their opinions on the matter. And so it's just the right time now to discuss with someone from Austria what's been happening on the other side and why, for instance, at this point, we're seeing a slowdown of these cases. So, whereas we were seeing hundreds of cases being enforced in Malta until, I would say, 6 months ago, now they've slowed down. And I've asked Nicole this question. So, what's been happening, Nicole? Why have we seen this slowdown? And I guess it's a number of reasons, right? From what's been happening in Malta to what's been happening in Austria. From the Maltese side, what I see is in February this year, there were 2 landmark judgments. So the Maltese First Hall of the Civil Court has decided that 2 of these player claims were not enforceable in Malta. These cases are now being appealed, but when we talked about this, you had something which was quite insightful to share in terms of what's been happening in Austria. Could you share this with me and our audience, please?
Absolutely. First of all, thank you for having me. And what is happening in Austria is essentially the plaintiff lawyers have become very creative. They are frustrated of not being able to enforce judgments in Malta. And Article 56A caused a lot of stir in Austria. Judges are called, plaintiff lawyers are called essentially. And so what they turn to is a legal instrument called ordination. So they asked the Supreme Court for an ordination decision, and the Supreme Court then determines a locally competent district court for enforcement. So that requires certain statutory complications. What is relevant here is 56A essentially opened the door to that, because now plaintiff lawyers can argue that enforcement has become impossible or unreasonably burdensome.
Which is normally something that could be argued for situations with countries with very weak judicial and legal systems, right?
It was a very bold move because historically, yes, you would use these ordination decisions in third world countries with no proper judicial system, certainly not in relation to an EU member state.
Right. And the Supreme Court in Austria has decided on these ordination claims.
By now, there are some in relation to .com domains, but now we've already seen some in relation to assets held in Maltese bank accounts.
And when you say you've seen claims relating to assets and Maltese bank accounts, so the Maltese banks are being solicited to comply with these Austrian ordination judgments, right?
Yes, so once you have the ordination decision by the Supreme Court, they appoint a district court that's competent, and then that district court sends out a garnishment order to a Maltese bank, expecting the Maltese bank to comply, which, to be honest, I can't imagine happening.
Yes, there would be issues of jurisdiction and competence. And yes, where I'm sitting kind of leisurely this afternoon, I tend to agree. Um, just also for the benefit of the audience, you refer to 56A. So we're here referring to the amendment to the Gaming Act, Article 56A, which was introduced pursuant to Bill 55, right? And this has caused quite a stir in the industry because basically what Parliament enacted in Malta is a law that does give a lot of protection to Maltese licensed operators. And it's been meant, you said, with I think you used the word appalled, right? Yeah, judges and claimants were appalled. I've also seen the European Commission react to Article 56A now with a notice of infringement proceedings. And we are aware that the government is contesting them or rather defending its position. We know this from the statement that the MGA released the same day the notice was given. And to be honest, all the information we have is coming from the FGA itself. Those proceedings are, of course, private. What's the gossip, for want of a better word, in legal circles in Austria about the infringement proceedings and how they might impact you there?
I mean, first of all, there is a subtle connection and from the infringement proceedings to these ordination decisions, because in quite a few we've read that plaintiffs they have the option to apply for an infringement proceeding, but they have no right to the initiation of an infringement proceeding. Therefore, this option does not remove the impossibility or the unreasonableness of enforcement. So since it was announced by the Commission that they started the infringement proceedings, I haven't seen any ordination decisions. And obviously, if the Supreme Court decides to issue some, I wonder how they will get around what they've written before in relation to the infringement proceeding, because it is here now.
Yes. That's interesting. So that could be another factor why we're seeing a slowdown here. So going back to how we started this episode, so we've seen a slowdown. Mind you, not all operators have seen a slowdown because from what I see, some still have quite a steady flow of claims. But the greater majority, we've seen an absolute slowdown because you're fighting two fronts, right? You're fighting first in Austria. You have to exhaust your remedies in Austria in order to give yourself a fighting chance in Malta to repel the enforcement because you have to exhaust remedies. It's one of the requirements in Brussels recast in order to for a court to apply Brussels recast and refuse to enforce on grounds of public policy, as the first court in Malta has done, incidentally, in the February judgment. And this is something I'm kind of keen to discuss. So the judgments that were delivered in February are judgments for applications that we filed before Article 56A, even Bill 55 was conceived, right? So we were arguing to the court in Malta not to enforce these judgments exclusively on grounds of public policies. And still somehow these concepts got commingled, I think even in the ordination actually, because how can you say that Article 56A is precluding enforcement when there have not been judgments yet, as far as I'm aware at least, where a Maltese court has refused enforcement on the basis of Article 56A. And I know it's a bit of a trick question, but I'm putting it out there to you. Do you think an ordination proceeding, as you described, should be successful if there haven't been judgments yet? Applying Article 56A is a question.
I apologize. No, not at all. It's fine. The ordination procedure is unilateral in nature. So that inherently carries the risk that the plaintiff lawyer will put forward arguments and documents, prospectively evidence, in his favor, right? So the Supreme Court only sees that side and then decides. And the obligated party, which is the online gambling provider, is neither summoned nor heard. They can put forward any arguments. And so you have this one-sided argument. So they're deciding on that. And you can see the ordination proceedings. They're all based on this Article 56A, so the amendment of the Gambling Act.
So it's almost a theoretical. So because Malta's passed Article 56A, amending the Gaming Act, and the way it was drafted, in theory, it was impossible to enforce, but they don't have data. So it's all very theoretical is what I'm seeing at this point. And do the operators have any chance of making submissions in these proceedings, of participating at all in these origination proceedings?
But the Supreme Court judgments are final. But the only chance that you have is going back to the district court level, seeing the decision of the district court, the garnishment orders, and trying to fight that.
And now these proceedings are halted because of the infringement proceedings against Malta on Article 56A.
They're not halted. We'll see how our common lawyers react and whether they will still apply or whether they change up their arguments in order to apply for an ordination decision.
It's very interesting. Anything else you can think of that might have resulted in the loss of appetite by plaintiffs and bringing their claims to Malta? Are we seeing that they're going to the banks? So we've seen a change of tactics. So perhaps the direct route has proven difficult.
Yes.
And now they're trying something new, very creative as well.
It's creative, I have to admit. It's old move for the Supreme Court too. And probably it won't be so successful because it does need cooperation from these Maltese institutions. So, and what we shouldn't forget is most of these player claims, nearly all of them are financed by third-party litigation funders. So they have already invested a lot of money into these proceedings. Court costs are very high in Austria, and they're not getting anything out. Yes. So maybe that's all can also put a hold to it, and they see first whether they can enforce at some point in time, and then they will start way more enforcement proceedings in Malta. And what we also noticed is a lot of them are probably waiting for the decision of the Court of Justice in relation to managing directors, because this is what really puts pressure on online gambling providers.
Yes, because now we've seen this new wave of claims and tort against the directors of operators, and that makes it very, it hits home, right? So the directors start, oh, he's threatened. This is not what they signed up for. Most of them don't own any shares in the companies that they are managing, and this is far beyond anything that they were expecting. Let's discuss these claims and torts against directors. From your experience, is there anything that has made them more or less successful? Is there anything that operators can do to protect their directors, or directors can do to protect themselves more?
So the question just asked me is very difficult because it's hard to protect the managing directors.
So as a managing director, most people take advice, and a lot of the advice that they receive is, this is legal. You have justifiable cause to be in the territory. So the Malta Gaming Authority has gone on record in evidence and the cases in Malta saying that the operators had a legitimate purpose for which they were operating in the territory. So even in that background, you think, would you say you completely disagree?
I also would advise managing directors to put forward these opinions, any other legal opinions that they had and that they sought at different times. So maybe in the early 2000s, later on in the 2020s, when the first Supreme Court judgments were issued. And it's definitely a question of culpability that we need to answer for that. So even if the CGU states, yes, the personal damages Austrian law applies, this doesn't mean that there is any automatic liability by the managing directors, because you do need culpability And what you also have to keep in mind is the statute of limitation, which is just 3 years of tort. Usually in these player claims, it's 30 years. For these torts, it's 3 years from the point in time that they had knowledge or possible knowledge of the damage and the person or the party responsible for it. So it also depends on how the court interprets that.
So what I hear you say is that everything is still in flux in Austria, just as much as it is in Malta. In Malta, we're waiting for the Court of Appeal judgments, and it's a wait and see for the infringement proceedings as well. And so there could be so many things, so many variables that will affect where things are going. And in autumn, you might have a change in the current licensing regime, right?
We at least hope for a draft being published for the new licensing regime. And we will also find out whether there will be one license like it is now or more licenses in June we hope for. We are hoping for a properly regulated market, which also enhances player protection.
Excellent. So I guess we'll be busy for the next few months there.
Definitely.
And thank you so much, Nicole. This was very insightful.